Thank you, Irene. Just when I try to find my presentation here, I want to explain that I'm in that position that I think many of you have probably found yourselves, where you submit an abstract and you have an idea for a paper, and then a couple of days before the event you start to work on it and find out that you were very, very ambitious. And so this is a work in progress and a first stab, if you like, at this topic. And it's what I really want to do. Take some time, does it? Yeah. What I really want to do is I want to look at the influence of the emerging human right to water, this discourse in international law, on the current ongoing reform of the Irish water sector. So I'll start by outlining the human right to water, just very, very briefly, its sources as a norm of international law, give some outline of its normative content or potential normative content, to look at the current reforms that are planned for the Irish water sector, look at the current legislative framework to see the extent to which there are gaps and what it actually requires and provides for. And then to look at the human right to water in Irish law, how it might, and this is rather speculative, but how it might find its way into Irish law and make itself relevant. As an instrument, or as a rule of international law, how it may impact on our understanding of protections within our constitutional framework, and how it may have impacts on our legislation, either the current legislation or what new legislation around the introduction of water charging and of Irish water, what that new legislation may look like. And in fact, we don't really know yet what that will look like, so it is a little bit speculative. And then just to highlight a few issues, which I would suggest, having regard to the discourse on the human right to water, that any new legislative framework really has to have regard to and really has to consider very seriously. First of all, the human right to water. We could spend a long time talking about the origins of this norm in international law. It's a derivative right. It's derived from, it's implicit in other rights that are contained in instruments of the International Bill of Rights, and that involves a number of issues. That adds to its complexity, to its normative uncertainty, to its legal uncertainty in terms of its basis. Is it a rule of international law? Personally, and I've worked in this area for some time, I'm not yet 100% convinced. And what does it actually require? So if we look at instruments that expressly provide for some form of water entitlement, not necessarily a human right, we have instruments such as the 1979 Convention on the Elimination of Discrimination Against Women, importantly the UN Convention on the Rights of the Child, etc., various other instruments. Also, of course, when we do unpack the notion of the human right to water, we see that a lot of the elements there are procedural, are good governance elements. And these we can draw from other instruments in international law and are very broadly and incrementally included in international law agreements and in international conventions. But it's as an implicit right that it's particularly important. And the key instrument, it's implicit in the 1966 International Covenant on Economic, Social and Cultural Rights. And it's derived from Articles 11 and Articles 12 on the right to health, the right to health and the right to the best attainable standard of living. Now, the key instrument, the key document that we have here is General Comment number 15 by the Committee on Economic, Social and Cultural Rights, published or adopted in 2002, which sets down in some detail what the human right to water would actually involve, or we should say the human right to water and sanitation would actually involve. It's a non-binding interpretation, but it's a very, very authoritative interpretation of these two key provisions of the Covenant, a Covenant which, of course, has been ratified by Ireland. Various other instruments are cited, but actually they only add to the confusion. The Covenant on Civil and Political Rights, the Universal Declaration of Human Rights, and then various other regional human rights conventions, although we don't really have any usable provisions in the European Convention of Human Rights in that regard. There's lots of other supporting legal texts and documents, from international watercourses law, the UNEC Protocol on Water and Health, etc., etc., but also state recognition, very important in identifying a rule of international law. Very commonly cited is the Constitution and legislative provisions in South Africa, decisions of the Supreme Court of India, but now maybe 50 states have some reference, some allusion to the human right to water in their national constitutional or legislative frameworks. It's been, well, at least tacitly identified in international investment law by ICSID. It's tacitly identified in the safeguard policies of multilateral development banks, MDBs, and other IFIs. And it has huge declarative support. Again, we're really looking at trying to identify a rule in international law, and these are the sources that the international lawyer will look at. Another source that I think is of immense importance for understanding it is these other forms of corporate, technical, and other forms of voluntary guidance. Guidance from on corporate CSR policies, on the UN Global Compact, OECD guidelines for multinational enterprises. Of particular importance where we're talking about private investors, where private investors come into a state and operate or otherwise invest in water and sanitation services. But all the way down to ISO technical requirements adopted by Technical Committee 224, 3 sets of guidelines on right to water indicators, etc. The work of the UN draft norms have been overtaken, but we have the work of John Ruggie, the Special Representative of the UN Special Representative of the Secretary General on Human Rights and Transnational Corporations. These are terribly important because they set down, there's a wealth of detailed technical guidance set down on what exactly we mean by the human right to water. And as we see, key elements are around affordability. This is what's likely to be important in Ireland. How do we model affordability? And there's a lot of guidance there. I would suggest that in our public law framework, when these issues are litigated, which they most likely will be, that this guidance will be very, very, very influential on decisions of the courts. An example would be recent and groundbreaking guidance by the African Development Bank in 2010, guidelines on cost recovery for urban network sanitation and non-urban network sanitation. And they've created this very complex model which has been adopted by many other multilateral banks, multilateral development banks and other institutions on how do we model affordability? How do we recover costs in a way that is sustainable, that is equitable, etc. So there's a lot of understanding out there about what this means. What's the content? Well, we could spend a lot of time talking about that and we're not going to. Substantive freedoms and entitlements regarding access to adequate, safe water and sanitation services. And we do have WHO guidelines on this, but they're not as useful as you might imagine. They don't really help us on quantum of water that people need. They help us much more on the quality of water than they do on quantum. And quantum is likely to be a key issue, as we see. Now, by adequate, we're talking about the availability of water, the quality of water, and the accessibility of water. And in accessibility, we're talking about, or in availability, we're talking about economic availability of water. So, again, affordability is absolutely central to this and will be for Ireland in the new regime of water charging. This paradigm of respect, protect and fulfil this human rights paradigm is very central. But we do have these core, I mean, remember, because it's from the Covenant on Economic, Social and Cultural Rights, all that's really required of states is that they move towards progressive realisation of these rights, rather than that these are immediate and absolutely invocable and enforceable. But there are certain non-derogable elements, and these would include the questions of non-discrimination, that no groups are disadvantaged in terms of their access to water and sanitation, and that each state take concrete and targeted steps within the parameters of what they can afford. Also, a great deal, and I think this is immensely important, a great deal of procedural, informational and participative rights are inherent to this concept of the human right to water. And these are normally among the non-derogable core obligations which are immediately enforceable. And I just give an example of the number of provisions from General Comment 15, which sets out the concept in detail, which actually are procedural rights, if you like, or participative rights. Concepts of non-discrimination. Environmental protection of water resources is, of course, central to this here as well. I would argue that in terms of our current legislative framework, the environmental protection of our water resources is not the problem. We have the laws. I think the social protection is the problem currently. So what reforms are planned for the Irish water sector? I'm sorry for rushing, but I'm trying to make up a little time. The reforms that are planned under the 2009 EU-IMF Memorandum of Understanding, we have committed to introducing domestic charges for water and sanitation services. And this is now firmly included in the programme for government, creating this new entity, Irish Water, which will take over the responsibilities of the existing water services authorities, mainly local authorities. But it's not just because of the EU-IMF. It's quite clear, looking at the programme of government, it's not simply because of the EU-IMF commitment, although obviously that provided the spur, but also massive investment is needed in the Irish water sector to meet the standards that we have to meet by 2015 under the EU Water Framework Directive. Massive investment is needed and some mechanism for for recovering these costs is required. Also reasons of efficiency. We tend to have a rather inefficient in terms of the number of people employed, water lost, etc. Again, it only really brings us into line with the requirements under the Water Framework Directive under Article 9.1. We use this exemption or derogation, but the norm required under the Water Framework Directive is water charging, cost recovery charging. And we have now quite detailed, we have a position paper, we have an implementation strategy and everything from the department. And so what's clear, what we know is going to happen is that we're going to transfer, there will be full transfer of the operations of the Water Services Authorities to this new company, Irish Water, by 2017. The EPA will be responsible for environmental regulation, whereas the Commission on Energy Regulation will be responsible for economic regulation, for setting the tariffs, for setting the costs. Many people say that our current legislation precludes privatisation. I don't think that's quite true. It requires continuing democratic control over water services. And again, privatisation is something, or elements of privatisation. Privatisation is always raised as this terrible spectre. Privatisation takes many, many, many forms. You know, there certainly is scope for it. In fact, one of the things you have to consider when you look at a policy which looks at universal metering, etc., it will be ripe for privatisation once all that is done. So let's consider that. So move towards universal metering and moving towards this system used in a number of other jurisdictions of a free allowance of water. So you only pay after a certain amount. Now the question of quantum is going to become absolutely central there. How much water will people be entitled to? The current legislative framework, and again there's very detailed work done on this, particularly by Danielle Cunningham, who works with Arthur Cox, has done two big papers in two parts in the Irish Planning and Environmental Law Journal, where she's analysed the fragmented and complex Irish legislative framework in tremendous detail. But you know, to draw a few lessons out of that, what we can see is that under Section 105 of the current Water Services Act 2007, charges are prohibited for domestic water and sanitation services. But this section has not been commenced under the legislation. Section 17, the Minister may introduce by regulation schemes for financial assistance, but there's no provision for a waiver of the costs, only for financial assistance. And we can generally say that even though they're fragmented, they're confusing, and we complain about them every year, the provisions on water quality and on environmental protection of water sources and on the water quality of drinking water are quite comprehensive, particularly because we have the Drinking Water Directive and the Drinking Water Regulations. But the environmental controls are generally quite comprehensive. Now, the human right to water in Irish law, how could it find its way into the Irish legal framework? Well, as an instrument of international law, Ireland is a party to the 1966 International Covenant on Economic, Social and Cultural Rights, and we're looking at Articles 11 and 12 on health and standard of living. It's unincorporated. It hasn't been introduced comprehensively by legislation into the Irish framework. So we have to look at it as an unincorporated agreement that Ireland has ratified. Now, the Irish government have stated, which I think is quite important, an intention to sign up to the optional protocol, which would provide an enforcement mechanism, effectively, for economic, social and cultural rights. So if we do, this could be one route where we could find ourselves, or the authorities could find themselves answering. Ireland, interestingly, abstained from the 2010 United Nations General Assembly resolution on the human right to water and sanitation. 122 states voted for, 41 abstained. Ireland was one of those that abstained. Ireland is a party to other conventions. For example, the UN Convention on the Rights of the Child, again unincorporated in a comprehensive sense, but there are others, the Disabilities Convention and other conventions which are relevant to the identification of the parameters and scope and normative legitimacy or status of a human right to water. More interestingly, let's look at how it may enter into, I'm looking at entry points, potential entry points into our constitutional framework. And if we look first of all at unenumerated constitutional rights, the right to bodily integrity is immediately going to spring to mind, remembering that Ryan and Attorney General in '65, which gave rise to our system of unenumerated constitutional rights, actually concerned fluoridation of the public water supply. So it's not a huge leap for us to move towards seeing the right to bodily integrity as being of central relevance. The right to dignity. Again, I know Conor referred to that this morning, and in many ways I was almost as happy not to reschedule my paper from the constitutional one, because Conor has grave doubts about the existence of a right to dignity and has written very eloquently on it. But again, the courts have identified the right to human dignity. It's included in the preamble of the Constitution, but also as an unenumerated right. In Award of Courts, Ms. Justice Denham has, number 2, has identified a right to human dignity, has linked it to rights of privacy. Privacy, of course, is central. In many other constitutional frameworks, privacy and sanitation have been very closely connected. A right of autonomy, again identified as an unenumerated right in Ray Ward of Court number 2, and again tied to a right to liberty, a right to due process, and a right that might be very important in terms of certain communities, the traveller community in Ireland, for example. Where we have expressed constitutional rights, how am I doing? Okay. Where we have expressed constitutional rights, we have the guarantee of equality under Article 40.1. If we look at Quinn's Supermarket and Attorney General from 72, tied to the right to dignity, this idea of equality being tied to the right to dignity. Again, in Ray Award of Court number 296, talking about the right to equality being a positive proposition, and it required authorities to eliminate indirect discrimination. So again, this is likely to become, hopefully I'll have time to explain why, likely to become important in terms of certain groups which might find it difficult to connect, to pay, to enjoy water and sanitation services. Also, we have these unusual directive principles of social justice which are set down in the Constitution. They're not directly applicable. They can't be used in testing the constitutionality of legislation, but they may be taken into account by the courts in interpreting that legislation. So they provide general guidance, or intended to provide general guidance to the Oireachtas in making legislation. But if we look at Article 45.4.1, protection of safeguarding the economic interests of weaker sections of the community, protecting against abuse, the strength and health of workers, men and women, the tender age of children. The language leaves a bit to be desired, but we can see where we can go with that. Again, what's the constitutional relevance of unincorporated international instruments? Well, Articles 29.6 and Articles 15.2.1 of the Constitution make it very, very clear that if there's a conflict between a domestic rule and an international instrument that the state has signed up to but is not incorporated into its national legislation, that in the case of a conflict, a direct conflict, the national rule, the domestic rule, will always prevail. Fair enough. Otherwise, the executive could usurp the role of the Oireachtas, etc. However, where there isn't a direct conflict, the State, Healy and O'Donoghue, 1976, saw as relevant Article 6 of the European Convention of Human Rights in regard to the issue of criminal legal aid, and linked it to the due course of law under Article 38 in the Constitution, the guarantee of due course of law protection, and other guarantees under Article 40.3. So an unincorporated instrument will be very, very important in helping us to understand what our Constitution means and how we should understand guarantees and protections in that Constitution. Again, in O'Leary and Attorney General 1993, Article 6.2 of the ECHR and Article 11 of the Universal Declaration of Human Rights were relevant with regard to understanding the presumption of innocence under Article 38. So there shouldn't be a huge difficulty in making the 1966 Covenant relevant to understanding the rights in our Constitution. What's the relevance to statutory provisions then? And again, there doesn't appear to be a difficulty. With using unincorporated international instruments to interpret, to apply, to understand our legislative rules. In State DPP and Walsh from 1981, the European Convention of Human Rights was clearly stated to be relevant by our understanding of our national laws. In Desmond and Glacken, Sir Justice O'Halloran said again that O'Hanlon, that it was relevant regarding the determination of this notion of public policy. And for a very focused example, Ms. Justice Finlay Gagan in Nawale and Minister for Justice said that the Convention on the Rights of the Child was directly relevant to understanding the requirements of the 1996 Refugee Act. The current statutory framework, just to highlight some of the difficulties in the current statutory framework and some of the characteristics of it. We have no duty on water services authorities to provide water services, believe it or not. There's no duty on them to do so. In the absence of a direction, a request or regulations introduced by the Minister. Now, of course, there are other obligations which tend towards this notion of provision. There's an obligation on water services authorities to prepare strategic plans, etc. Where they do provide water, there's a very clear duty to provide water of a sufficient quality or an adequate quality, but not necessarily to provide water. There's no duty to provide toilet facilities in public places, although of course in relation to certain buildings and buildings used for certain uses, for public events, etc., planning law, residential tenancy law, normally operates to include conditions requiring that these facilities are provided. But there's no clear comprehensive obligation on state authorities to provide it, on the water services authorities currently to provide it. One needs permission to connect to water supply and to the sewer, and it's a fence to connect illegally. Now again, this is to protect the integrity of that infrastructure, but this could give rise to certain problems. For example, where we see one questionable abuse here is that the authorities can opt not to connect for unauthorised structures or structures subject to unauthorised uses under planning law. Again, I can see how that could certainly give rise to difficulties. To enforce planning law by withdrawing water and sanitation services would certainly run counter to the spirit and intent of General Comment number 15. Water services authorities may, for example, restrict or prohibit water use. Now that's in the context of droughts and for purposes of conservation. And water services authorities are given immunity from liability for any losses accruing. Again, that might raise issues of reviewability and accountability. I think what's quite important here is that both the Minister in respect of service quality and the EPA in respect of environmental quality and drinking water quality can issue compliance notices. They have a compliance notice procedure and can seek High Court injunctions. But the public have no role in this. The public cannot request or outside an ordinary judicial review require that these steps are taken. So again, the individual is left out of these entire processes. Now, this basically highlights a number of issues that we really have to consider and that we really have to get right in the legislative framework that we create. In relation to metering, I wonder if we have realistic plans for the effective rollout of metering. If you look at the experience in the UK, from 1990 or thereabouts, the UK has been installing water meters, now on a different strategy. But they aim to have 80% penetration of the market by 2020. So the idea that we will have it all rolled out in a year, I don't think that's credible. What will installation charges look like? How will we recover the cost for installation? And this has been controversial in many jurisdictions. And what do we do in the meantime? Interim flat charges. How do flat charges deal with large households, etc.? So it's raised a number of issues. What will the free allowance be? Suggestions have been made around, not officially, but suggestions have been made around 60 litres per person per day, per capita per day. In South Africa, it has been officially 25, and then the courts have raised that to 50 and back to 25, and this has been litigated regularly. How will quantum be calculated? How will it be allocated? On the basis of households, on the basis of individuals? Again, it becomes quite complex. Affordability. How do we assess affordability? How do we model it? What will we do? Will we introduce differential free allowances? Will we give different free allowances for people who may have different requirements? Will we introduce welfare supplements? I mean, our current legislation doesn't allow for waivers. So welfare supplements, again, that would have to be linked up with social welfare law. Will we have progressive charging where one pays more for the more they use? Will the swimming pool owner have to really seriously consider filling it in? Disconnection, always a key issue. What kinds of safeguards will there be around disconnection? What kinds of appeals? And they'd have to be cheap and cheerful appeals. How will this work? What kind of guidelines around disconnection, particularly in the context of any measure of privatisation? And then connection. What about vulnerable people? What about transient communities? What about people who aren't easily, people in unauthorised structures or structures that are used for unauthorised uses, etc.? And this would require, make really sort of developments in respect of planning and development law, equality law, residential tenancy law, etc. And then general issues of governance, which I haven't had time to develop with you, and I really would have liked to. And this is around transparency, participation, reviewability, and accountability. I think a lot of the value in the human right to water concept, we could debate for a day whether it exists as a rule of international law. But we can understand it as a product of the phenomenon of global administrative law. That these universally recognised concepts of good governance are coming to us from a multitude of different sources. We find it everywhere in our own law, incrementally in our own law. And the governance element here, where people are actively engaged in, where the process is transparent, people are engaged in policy making, reviewability of decisions, for example, around disconnections with connection policies, etc., and then accountability of officers. These are absolutely central and have to be addressed. Sorry if I've taken more time than I need.